Hi all everyone and welcome to my video. So in today's topic we're going to discuss about the seditious law, which is Article 124A. But before we get into it, I have a quick announcement to make. That is, I'm going to start a series of classes in online platform about civil services, and this is especially for school going students upwards statistics standard. So do watch till the end because I'll be giving out all the informations related by the end of this video. So earlier this year, which is in 2021, the Chief Justice of India, that is Justice Ramana, had expressed openly about the seditious law. He even called it a very colonial law and that this is very much against the democratic ideals of our nation. But what is even more surprising is that our Law Minister, Mr. Judicial, has openly expressed in the Parliament that this seditious law is there to stay. There is no proposal to scrap off this law and it's going to be staying for the time being. So before we get into the topic, I think it's pretty much important for us to know the relevance of its topic. Yes, this comes under your GS paper 2, which is polity and constitution, and GS paper 2, which is governance, government policies and initiatives. So now let's get into the dimensions of the topic. So what is sedition? So sedition, which comes under the Indian Penal Code of 124A, which is defined as any action that brings or attempts to bring hatred or contempt towards the government of India and has been illegal in India since 1870s. So we should also keep this in mind that this was the same rule imposed by the colonial period, that is the Britishers, to suppress Gandhi, Tilak and all these national freedom fighters. And during those periods, the expression of these national freedom fighters were called to be seditious. Now let's rewind even further. That is, what is the historical background of the seditious law? So this could be said historically from the Elizabeth England. That is, when you criticize a king, were you fomenting a rebellion, it is a crime against the state. So essentially this law was born in a place where there were no democracy but only monarchy and anarchical government. And when the same Britishers ruled India, they had a fear in their mind that these people, the natives, are gonna overpower them, especially with the Wahhabi rebellion. And like I said, Gandhi and Tilak were trialed under this law during those period. And now let's talk about the seditious law in the present democratic setup. Yes, dissent is a very healthy form of expression in a democratic nation. But what happens when people openly comes in a rebellion against the government? And what happens when the others starts to instigate some sort of rebellion against the government? So this seems to be like a hot and cold policy or a regulation set up by the government, because it has historical background being imposed by the Britishers so that they can have a suppressed voice of these freedom fighters. And it was established here in 1870s by Thomas Macaulay. Even though a series of amendments and changes had happened throughout the seditious law, it essentially remains the same, that you can't speak against the government. And sedition is a cognizable, non-compoundable and non-bailable offence under which sentencing can be between 3 years or up to imprisonment for life. So there is an element of this law being misused by the government, so it's totally relative upon who is using this. So after all the evolution and adaptation, we have section 124A of the Indian Penal Code. So what comes under right now? So whoever by words, either spoken or written, or by signs, or by visible representations or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added or with fine. And also one more side note that I would like to add on is that if a particular person has ever been on trials for this particular seditious law, this person can never get into any forms of government jobs in the union as well as in the state government. And they also have to live without passport and must present themselves in the court as and when required. So in short, we should conclude that Chief Justice Ramana's reply or comment on this particular law was very much justifiable, because there is a potentiality, there is a chance or a room for this particular law to be misused. And yes, it even violates the Article 19 of our Constitution, which is a basic fundamental right. We all have the right to express, right for speech. So this particular law is very much in loggerheads with our basic fundamental rights of expression of speech. And our Justice Ramana even uses phrase that when a person is given an axe, instead of cutting a wood, he actually cut down the whole forest. So this was a comment that he passed on the basis of this particular law. And Chief Justice questioned why a democracy required a legislation that had been used by the British to arrest Mahatma Gandhi and Bal Gangadhar Tilak. And Mr. K.K. Venugopal, who is the Attorney General of India, who even appeared as on the behalf of the government, said that there is no reason for striking down this law. The court has already requested a formal response from the government by giving notice on a petition to quash Section 124A submitted by Major General S.G. Bombardkari. And not just him, even the petition filed by the famous journalist Arun Shourie and the NGO Common Cause, both represented by a counsel Prashad Bhushan, contains Section 124A lacks even a presumption of legality. So apart from being called a colonial era law, or apart from being called to go against some basic fundamental rights of a human dignity, so what all are the criticisms that this law has to face? So this is against a democratic foundation, it is of lower conviction rate, it's a vague provision of seditious law, and the last point is perception of law. That is, everything is relative, and this could be even viewed as a draconian law. So what now when the seditious law becomes more constitutional? So that is, in 1962 there was a chance for the Supreme Court to strike down this law, even though it was proved that this comes in against the basic fundamental rights, that is Article 19, that is expression of speech of the Indian Constitution. But even then it wasn't struck down. Further, this section does not get protection under the Article 19 subclause 2, that is reasonable restriction. It may be mentioned that in this context that this could be labeled as a form of reasonable restriction, though included in draft Article 19 was deleted when the article was finally adopted by the Constitution Assembly. So this clearly shows that constitution makers did not consider sedition as a reasonable restriction. However, the Supreme Court was not swayed by the Constitution Assembly. It took advantage of the words "in the interest of public order" used in Article 19 subclause 2 and held that offence of sedition arises when seditious utterances can lead to disorder or violence. So yes, I would like to conclude this video by saying is that there is a room for this law to be misused. There is a chance for the executive and even to a large extent legislative to misuse this law and to impose lots of draconian laws on the basis of that. But luckily enough, we are in a democratical setup where the judicial is supreme, and more importantly, the judiciary are the ones who look into these judicial reviews, looks into these laws, policies, everything set up by the executive and the legislative. So I hope that no matter what they are doing, we also have someone who looks after us, someone to look after the democratical setup, the more importantly the Constitution of India. So that's it for today's video. Thank you so much for watching, and bye-bye. So hi all everyone once again. So if you remember, I did drop in an announcement in the beginning of the video. So yes, I'm going to start courses and classes for school going students for 6th standard upwards, and they're going to be in 2 batches, that is 6th to 8th standard in 1 batch and 9th upwards to 12th in 1 batch. So the classes are going to be for the weekdays, that is in the morning from 6 to 7 and 7 to 8. So just ring in this number and ask for further details about everything that you want to ask about. And thank you so much again, and bye-bye.